In this course, we'll explore the role of law from a law enforcement perspective. Our laws serve as written embodiments of society's ethics and morals. Laws are said to be declarative as well as active. They declare correct behavior and serve as a tool for law enforcement. While natural law refers to the belief that some law is inherent in the natural world and can be discovered by reason. Positivist law refers to those laws written and enforced by society. This type of law is on human construction and therefore fallible. Early codes of law did not delineate between what we now distinguish as public wrongs, criminal laws, and private wrongs or torts. Criminal law is more closely associated with enforcing the moral standards of society, yet it by no means is comprehensive in its coverage of behavior. Laws, in the form of statutes and ordinances, tell us how to drive, how to operate our businesses, and what we can and cannot do in public and even in private. They are formal, written rules of society. Yet they are not comprehensive in defining moral behavior. Good Samaritan laws make it a crime to pass by an accident scene or witness a crime without rendering assistance. Some states do have laws called Good Samaritan laws, but they're civil and protect medical professionals who stop at an accident scene and administer aid to victims. Law controls behavior by providing sanctions, but also, perhaps even more important, by teaching people which behaviors are acceptable and which behaviors are not. Law is the final word, but it's also dynamic, shifting to reflect changing belief systems. Just as important as a tool for behavior control and change, the law provides a blanket of protection for individuals against the power of the state. Under the societal contract theory, law is a contract. Everyone gives up some liberties and in return is protected from others and have their liberties restricted as well. How much liberty should be restricted and what behaviors should be prohibited? Rough formulas or guidelines indicate that the law should interfere as little as possible with natural liberties and should step in only when the liberty in question injures or infringes the interests of another. The justifications for law most often cited are preventing harms to others, preventing offensive behavior, preventing harm to self, and protecting societal morals. Each of these will be discussed next. John Stuart Mill proposed the harm principle, which basically is the idea that every individual should have the utmost freedom over their own actions unless they harm others. There are some actions that do not exactly harm others but give rise to disgust or offense. Many laws can be described as examples of legal paternalism, which means that the state tries to protect people from their own behavior. The strict libertarian view would hold that the government has no business interfering in a person's decisions about these behaviors if they don't negatively affect others. It may also be true that there are no harmful or potentially harmful behaviors to oneself that do not also hurt others, however indirectly, so society is protecting others when it controls everyone. These rules try to create a balance between an individual's liberty and government controlled. Impaired by lack of knowledge or competency, the restriction should be as limited as possible, and the laws should seek only to prevent a serious and irreversible error. The law also acts as a moral agent of society, some say in areas where there's no moral agreement. This rationale is called moralism. Understanding the justifications of the law is essential to effective law enforcement. Basically, paradigms are models of how ideals relate to one another, forming a conceptual model of the world around us. A paradigm helps us organize the vast array of knowledge that we absorb every day. We see the world and interpret facts in a way that are influenced by our paradigms. Let's take a look at the three paradigms that might affect our view. The consensus paradigm views society as a community consisting of like-minded individuals who agree on goals important for ultimate survival. The consensus view would point to evidence that people agree on, for the most part, what behaviors are wrong and the relative seriousness of different types of wrongful behavior. In the consensus paradigm, the idea is that most people have similar beliefs, values, and goals, that law is representative, that law reinforces social cohesion, and that law is value neutral. The conflict paradigm views society as being made up of competing and conflicting interests. According to this view, governance is based on power. If some win, others lose, and those who hold power in society promote self-interest, not a greater good. Those holding a conflict paradigm would point to laws against only certain types of gambling as evidence that the ruling class punishes the activity of other classes more severely than their own activities. Generally, in the conflict paradigm, law is repressive, law is a tool of the powerful, and law is not value neutral. The pluralist paradigm shares the perception that society is made up of competing interests. However, pluralism describes more than two basic interest groups and recognizes that the power balance may shift when interest groups form or coalitions emerge. Pluralism views the law as influenced by interest groups that are in flux. Some interests may be at odds with other interests, or certainly the interpretation of them may be. Perhaps the best explanation of the long-standing distrust of lawyers is that they are typically representing trouble. People don't require a lawyer unless they believe that a wrong has been done to them or that they need to be defended. The public tends to agree with a stereotype of lawyers as amoral, motivated by money, and with no conscience or concern for morality. Apparently, even lawyers don't think much of their profession. A National Law Journal study found that over 50% of lawyers describe their colleagues as obnoxious. The ideal of the justice system is that two advocates of equal ability will engage in a pursuit of truth, guided by a neutral judge. The Supreme Court held that the Sixth Amendment guarantees that poor criminal defendants receive legal representation. However, the reality is the system of indigent defense in this country is extremely underfunded. Several private and public advocacy groups have brought attention to the fact that indigent legal aid is so overburdened that representation likely falls below constitutional requirements. The Department of Justice investigation of Ferguson, Missouri's police department did not find racial discrimination in the police force, but it did find that the city's revenue was largely based on funds from petty arrests and fines. It seems that after the recession in 2008, large and small municipalities began to utilize the criminal justice system as a revenue system. If poor people can't pay fines, they incur even heavier financial penalties for non-payment, which then lead to jail sentences where, in some locations, they are charged for medical care and necessities that leave them with even more debt. The Vera Institute's Manhattan Bail Project study in 1962 found that those released on personal recognizance were just as likely to return for trial as those released on bail. The findings led to the Bail Reform Act of 1966 that eliminated financial bond for most federal defendants, and to jurisdictions around the country adopting personal recognizance programs that allowed low-risk individuals to be released prior to their case being adjudicated. Personal bonds save money for taxpayers by reducing jail populations and help those charged by allowing them to continue to work and pay bills before resolving their court case. Today, advocates are once again pushing for jurisdictions to consider pretrial release for low-risk individuals. It appears that some jurisdictions have decided to charge even people who have charges dropped. In Ramsey County, Minnesota, even when someone is arrested and then is released with charges dropped, they are charged a booking fee. An extremely pervasive issue across the country seems to be poor people being jailed for non-payment of court costs and fines. In several news articles and studies, examples of individuals who receive a traffic fine of several $100s and because of late charges and surcharges end up owing more than the original fine several years later. In March 2016, officials at the Justice Department wrote a letter to courts in all 50 states warning them that jailing individuals for non-payment could run afoul of the law. The National Task Force on Fines, Fees, and Bail Practices has now released guidelines to help judges determine when they should assess fines and when they should not. The dangerous reality is that when fines from offenders are necessary to fund city services and various criminal justice components, there's no incentive to reduce crime. Some refer to the practice of criminal law as the confidence game because the prosecutor and the defense attorney conspire to appear to do something they are not, adversaries in a do-or-die situation. Another perspective describes our courts as administering bureaucratic justice. The bureaucratic system of justice involves procedures and policies that, although not intentionally discriminatory, may contribute to a perception of unfairness. For instance, a major element in bureaucratic justice is the presumption of guilt, whereas the ideal of our justice system is a presumption of innocence. Many would argue that an attorney must never abandon his or her own moral compass. The fact of the matter is, sometimes that occurs. Historians indicate that this dilemma has been problematic for lawyers since the first ethics codes were written. The following are the types of positions described and defended as contrary acts. The legal agent. One position is that the attorney is no more than a legal agent of the client. The lawyer is neither immoral or moral, but merely a legal tool. A special relationship. A more moderate position is that the loyalty to the client presents a special relationship between client and lawyer, like that between a mother and a child or with a trusted friend. Moral agent. The third position is that the lawyer is a moral agent who must adhere to their own moral code. The client's interests come first only if they do not conflict with the lawyer's morality and ethical code. Some principles to be considered moral are as follows: treat others as ends, treat clients as others relatively similar, and do not deliberately engage in deception, and also be willing to make reasonable sacrifices. Further, do not give money for wrongful purposes, avoid harming others in the process, be loyal to your clients, and make your own moral decisions. The rationale for these principles seems to be an amalgamation of ethical formalism, utilitarianism, and ethics of care in that a lawyer should be concerned when the other side may be victimized or harmed by the actions of one's client. The legal agent position is that it is impossible and unethical to substitute one's own moral code for one's client. Research indicates that the position taken by attorney depends partially on whom they represent. It should be noted that the model rules for attorneys do show glimmers of the moral agent idea. In 1983, the ABA switched its endorsement of the Model Code as a general guide for ethical behavior to the Model Rules of Professional Conduct. The model rules continue to be revised periodically, responding to changing sensibilities and emerging issues. The rules require that attorneys zealously protect and pursue a client's interest within the boundaries of the rules while maintaining a professional and civil demeanor towards everyone involved in the legal process. Critics charged that the rules have replaced earlier ethical codes that expressed ethical norms based on a moral tradition with regulatory prohibitions. Section 1 of the rules is titled Client-Lawyer Relationship. This section offers rules that require an attorney to maintain a level of competence in his or her field and to not take cases that are beyond his or her expertise. Section 2 offers rules concerning the lawyer's role as a counselor, and Section 3 covers these situations where an attorney is pursuing the client's interest as an advocate. Another section of the model rules is titled Transactions with Persons Other Than Clients. In this section, rules require the lawyer to maintain truthfulness in statements to others and not communicate with opposing parties except through their attorneys. Other rules cover practices concerning unrepresented persons and the rights of third persons. The section on public service mandates that lawyers provide some pro bono, free legal service and otherwise contribute to the legal community and society in general. To help guide judges in their duties, the Model Code of Judicial Conduct was developed by the ABA. The 4 canons of the code are as follows: a judge shall uphold impropriety, a judge shall perform duties impartially, a judge shall minimize the risk of conflict, and a judge shall not engage in political or campaign activity that is inconsistent. When judges are elected, they must solicit campaign contributions. There has been recent attention to the vast sums of money that have flowed to judicial campaigns in recent years. One might expect that judges who receive large campaign contributions from individuals or corporations would recuse themselves when these corporations have cases before the judge, but that doesn't always happen. There's a relationship between contribution and judicial decisions. The more campaign contributions from a business a justice might receive, the more likely the judge decides in favor of business litigants. Even in local races, bias is introduced when local attorneys are the largest donors to judicial campaigns. The Model Code of Professional Responsibility dictated that lawyers should be temperate and dignified and refrain from illegal and morally reprehensible conduct.